Good morning, namaste. Welcome to all on our 66th webinar, which is a part of the AAA weekly webinar series. And the subject today is again, recent judgments from NCLAT. May it be Chennai or may it be Delhi. Even yesterday, there was an IP conclave. In that IP conclave at India International Center, I participated along with many other insolvency professionals, and the president of NCLT and 7 other members were also present, along with the chairman of IBBI and whole-time members of IBBI, and various other officials were also present. So there were a lot of discussions regarding the claim verification. So that's also a very, very important subject, which actually we should keep discussing, that the claim verification somehow actually is important. Now, when we say the claim verification, so there are a couple of judgments that we have on claim verification. I will just, I will also try to find out in case I will be able to deliberate on those, whatever was in fact deliberated in the webinar also, in the IP conclave also. First of all, let me go through my, let me share my screen. So the last webinar, we also discussed various judgments regarding the vacation of properties and the jurisdiction of adjudicating authority in ordering eviction from the properties which are part of the liquidation estate of the company. Now, today also there are a couple of judgments on this. There are a couple of judgments on claim verification, and one judgment which was in fact referred in the discussions many times yesterday in IP conclave, that was Puneet Kaur judgment, which is very, very useful in the case of home buyers. So I'll just go through one by one. The first judgment is SMS Foundation and Investment LLP versus Harsha Engineering Private Limited. And this is in the case of Harsha Exito Engineering Private Limited. It is a Chennai NCLAT judgment from Justice Venugopal and the technical member, Ms. Sirisha Marla. Now, in this particular case, the RP rejected a claim, and because the claim was belated, and the application also, the application filed by the, that was also rejected by the adjudicating authority, saying that it is a belated claim, and it was basically an investment of 16.5 crore. 16.5 crore was invested by Harsha, by the applicant in Harsha Exito Engineering Private Limited. Now, the RP rejected it. Sorry, it was not a belated rejection. It was a rejection based on, because the RP found documents that this particular claimant is a shareholder of the company. So he further gave money for allotment of shares. And then in fact, the corporate debtor later, via the board resolution, revoked the MOU. And there was an MOU also entered between the shareholder, There was an MOU also. So it seems that the transaction is between the related parties. The related party means the SMS Foundation and Investment LLP. First, they thought of investing in shares. When they saw that the company is going into insolvency, then they, in fact, changed their mind to make them as a financial creditor. And then the corporate debtor, because it's a related party, so the corporate debtor passed a resolution in the board. And in the resolution, the original MOU, which was basically for investment in shares, that was converted into a loan agreement with an interest of 15% per annum. And the managing director also had written a letter to the applicant stating that the amount received was converted as equity shares in the name of the applicant, and the share certificate has been handed over. Now, a related party transaction, which is seemingly related party because the name is also similar. Originally, it was a proposal for investment, and MOU was also entered. Later, the MOU was converted into an investment and a loan, and an interest also was 15%. The managing director also written a letter that the amount has been converted into equity shares, but that's not enough. There are other formalities which are required in case a share has to be allotted. So when this CIRP started, the RP rejected the claim, and RP said this is he's a shareholder. So therefore, the application was filed before the adjudicating authority, NCLT Chennai, and the main issue was whether the claim of the appellant is required to be admitted in the capacity of the financial creditor or not. So the adjudicating authority held that the applicant is one of the shareholder, and the respondent was right in rejecting the claim. Respondent was the RP. Now, the applicant's real intention was not to hold any shares in the corporate debtor. The applicant ought to have taken steps in case that was the intention under Section 59 of the Company Act for ratification of his name in the Register of Companies. So the NCLT Chennai found, based on the representation made by the respondent, that the person is still a shareholder. His name appears in the Register of Members. Whatever returns has been filed by the company like MGT7, it also have that name as a shareholder. So simply by a ledger extract, so it was a related party transaction. So what they did, they canceled the MOU, they converted the shares into a loan, and then they created a ledger account, which is actually showing a loan account. So this loan ledger was also presented. Now, first of all, they challenged that the RP is doing adjudication, and whether the RP has the power to do adjudication regarding claim verification. So this was also one of the very important question, and the appellant was saying that the shares were never duly transferred under the eyes of the law, and therefore the appellant are not shareholders of the corporate debtor. And they also placed reliance on Vintage Hotels Private Limited versus Ahmad Nizar Madin Kunhi. So these judgments were also presented, like some with income tax and some for the Companies Act. So the only agreements subsisting between them, they were saying that it is all other agreements are cancelled. The only agreement which is subsisting is the loan agreement. And then they were saying that the RP of the corporate debtor acted ultra vires to his duties and had indulged in adjudicating the claim of the appellant. In this case, the Honorable Supreme Court has held, in the case of Swiss Ribbon, has observed that the resolution professional has no adjudicatory powers. Now, in this case, the respondent means the RP, the RP said the appellant was involved in the management of the company, because he was the RP. He knew that the appellant was also involved in the management of the company post his investment, and the loan agreement was for a future transaction. Now, the appellant also had an email ID. The RP submitted that he also had an email ID on the company's domain name. The endorsement regarding share transfer was made at the backside of the share certificate, and the same was handed over to partners. Having participated actively in the day-to-day functioning of the decision-making process of the company, and being a shareholder, any transaction between the appellant and the corporate debtor cannot be qualified as a financial debt. This is, of course, not, this contention is not correct, but the NCLT observed that a ledger account to be read with the statements. NCLT very clearly said that a ledger account has to be read with the balance sheet and the financial statements together with the auditor's report filed with the ROC. It is a settled law that the financial statements filed with the ROC have greater evidentiary value than that of a ledger statement, which is an internal document. Third, the duty of the RP is to collect and collate the claims, and a mere rejection of the claim by the RP cannot be considered to be an adjudicatory function, keeping in view Regulation 13 of the CIRP regulations. So Just rejecting is not an adjudicatory function. Now, in case we see regulation 13 of the CIRP regulation, although in the code it is written as the RP only will collect and collate. However, the word verification is also written in regulation 13 of the CIRP regulation. Regulation 13 says that the interim resolution professional or the resolution professional, as the case may be, will verify every claim as on the insolvency commencement date within 7 days from the last date of receipt of claims, and thereupon maintain a list of creditors containing names of creditors along with the amount claimed by them, the amount of their claims admitted, and the security interest, if any, respect of such claims, and update it. The list of creditors shall be available. So this is the regulation 13, and the primary focus is that this RP is also bound to verify the claims. Now, the decision of the ANCLAT that the duty of the RP is to collect and collate the claims, and a mere rejection of the claim by the RP cannot be construed to be an adjudicatory function, keeping in view regulation 13 of the CIRP regulations. Now, in this case, the MGT7 available from the MCA portal, read together with the auditor's report and the endorsement of the appellant on the share transfer certificate, all clearly establish that the shares were indeed transferred in the name of the partner of the appellant, and therefore this tribunal is of the earnest view that there are no substantial ground to interfere with the order of the adjudicating authority, so the appeal dismissed. Now, in this case, also referring to such kind of scenarios, when the entire like a group of 7 NCLT members and the president were saying that whenever you reject a claim, you must record reasons and you must provide reasons of rejection. Now, in this case also, then the president, honorable president NCLT said that I know one case that the RP even went to ANCLAT that this order or this direction of the NCLT is incorrect, and they are now putting a responsibility on me to provide a reasoned order. I am not supposed to order. I am not an adjudicate. I am not adjudicating it. So, but then again, like what we see, whenever we reject a claim, we must provide a reason for the rejection so that the other person goes. It was also a directions given to the IPs by group of members NCLT that we must give a reasons for the rejection of the claim, and those reasons finally can be used by the claimant filing an application to NCLT. However, in this case, the claim, it was whatever the RP had done, that was considered appropriate, and verification of the claim is his duty, and it is not adjudication, it is a verification. Now, verification, in the process of verification, he has the power to accept or reject. But the only thing that the members added that there must be a reason recorded somewhere. Now, what recorded somewhere means, one, it can be in the minutes of the meeting when we discuss such claims in the CoC meeting, in case we do that. And in case we don't discuss these claim issues in the CoC meeting, then separate intimation, separate communication must be made to the claimants whose claim has been rejected. Because see, whosoever claim has been accepted, that actually they will come to know from the list which will be published at the website of IBBI. So the people who are not getting any acceptance, they should actually get some communication that it has been rejected. So today we also will be taking some people online in case there will be any questions. So let me handle the first of all, a couple of questions on the claims. Once this claim issue would be completed, then I will call some interested parties to ask their questions, and I will also give them the mic to speak. Now, the second judgment again is from NCL 80 Chennai. This is Mr. Toral Rathod versus Mrs. Gopal Sami Ganesh Babu. It is in the case of Milan Textile Enterprises Private Limited. This judgment was passed on 2nd of June 2023, very, very recent, again passed by Justice Rakesh Kumar and Ms. Shrisha Marla from the Chennai bench. Now, this is a case of the CIRP of Milan Textile Enterprises Limited. It started April 22 is the case. The claim, belated claim was filed by a person, and that also in incorrect form B. Then again, the correct form was filed by RP, in fact, informed by an email that the form is incorrect and it also exceeds 90 days. So he has no power, and he only have given an option that you may approach adjudicating authority. So the claimant filed a fresh claim in correct form and then filed an application before NCLT, and NCLT dismissed the application, and reliance was placed on Isha Bhattacharjee versus Managing Committee of Raghunathpur Nafar Academy, wherein the Honorable Supreme Court held that condonation of delay cannot be granted as a matter of course, and such a liberal approach cannot be taken when there are no proper grounds given by the appellant or applicant. Aggrieved by the same, preferred an appeal, and this is what is the judgment, this is what is the issue before NCLAT. Whether filing of a claim under a wrong category can or cannot be substantial ground for condoning the delay, although even the wrong form was also filed belated. It was also, the first form was also belated. So the delay of 49 days in filing a claim as a financial creditor is neither willful nor wanton. The adjudicating authority did not address to the, this was what was the claimant was saying, that did not address to the merits of the matter and has erroneously relied upon Isha Bhattacharjee case, wherein there was almost 7 years delay, whereas in this case the delay is of a short period of 49 days. Then the appellant also referred, the claimant also referred the judgment of Honorable NCLAT Principal Bench, and that is Puneet Kaur versus KV Developers Private Limited. And also in the case of Punjab National Bank versus Animesh Mukhopadhyay. Now, this Puneet Kaur judgment was also referred to in various conversations yesterday in the IP conclave. I definitely would like to deliberate on this Puneet Kaur also, because Puneet Kaur is one judgment which is very, very useful for all the real estate cases. And this has actually been, although that was not part of my PPT, which I in fact studied today morning, early morning, and then that is on the Word. I will just shift to there. First of all, let me finish this case. And after that Puneet judgment, then I will take questions and I will allow a couple of people to interact publicly with everyone. Now, going forward, in this case, the respondent said that the resolution plan of the SRA was approved by the CoC, and the approval of the said application is pending before the adjudicating authority. The claim petition was filed before without any proof before RP, which is 139th day of the commencement. It is not 49, it is 139th day of the commencement of the CIRP, because he was taking 90 days as my right and then 49 delay. So he was saying 49 delay is only there, but then 90 plus 49, 139th day. So the adjudicating, this was the claimant saying, the observations of the NCLAT saying the actual time of delay in submitting the claim form is 125 days, because the original, it was supposed to be submitted within 14 days of the public notice. So from that day, the delay was 125 days. Now, the claimant approached the adjudicating authority with a further delay of 100 days. And the only reason that was given is they were seeking legal advice. Now, the reliance placed by the appellant in the matter of Puneet Kaur versus KV Developers cannot be taken into consideration, as the facts of that matter are distinguishable, as the case relates to home buyer, where there were builder-buyer agreements. Now, one thing that we all must understand, that there are two views which are being taken by the judiciary. One view is the claims of the home buyers, and the other is the other claims. Now, the other claims, it is very well said that the beyond 90 days, the RP does not have power to admit any claim unless the new regulation which are proposed by IBBI, in case those regulations finally will be notified, then there may be some change. Otherwise, as of today, after 90 days, the RP doesn't have any power to admit any claim. Number two, in the case of home buyers, the different duties have been given to the RP. That in the case of real estate cases, the duties are completely provided in Puneet Kaur versus KV Developers Private Limited. So in this particular case, the NCLAT said that there is no substantial ground. IBC is a time-bound process which has actually been repeated by the Honorable Supreme Court many times. The cost of reputation, the explanation given by the appellant herein is neither substantial nor can be construed as a sufficient cause. Therefore, the appeal was dismissed. Now, what we have seen today, that the claim of a shareholder, which was trying to be converted into a loan, that was rejected. Now the belated claim was also rejected. But now, like in case we see this judgment, it says that the reliance was placed on Puneet Kaur versus KV Developers. Now let us say what the Puneet Kaur has said. Now this Puneet Kaur versus KV Developer judgment is dated 1st of June 2022. It is from NCLAT New Delhi and it is from the principal bench, which is presently being relied by the entire judiciary in the IBC. This judgment is being relied, so everyone must know that these are the judgments where the 5 appeals were taken together and 5 separate appeals were filed by the separate home buyers. Now the fact is they did not file their claim. The only fact is that it was a belated claims. Now the questions of law, 4 questions of law. 1, whether the adjudicating authority has rightly rejected the IAs filed by the applicant seeking directions to include their claim which was belatedly filed. This was the first question of law. Whether after approval of the resolution plan by CoC, not by adjudicating authority, the claim of the appellant stood extinguished. This is a second question of law. The third question of law is whether the resolution professional was obliged to include the details of the home buyers as reflected in the records of the corporate debtor in the information memorandum, even though they have not filed their claim before the resolution professional within time. Fourth question of law, whether resolution applicant ought to have also dealt with the resolution plan regarding home buyers whose name and claims are reflected in the records of the corporate debtor, although they have not filed their claims. Now we'll see answers one by one. So first of all is whether the adjudicating has rightly rejected or not. Now in this case, there is no dispute between the parties that the claims were belated. Now the RP rejected the claims placing reliance on the following 2 judgments. One is the Mukul Kumar versus RPS Infrastructure and the other is Harish Polymer Products versus George Samuel RP of Jason Decor Private Limited. So these are the 2 judgments which were relied upon and the claims were rejected being belated. And also it was said that now since the CoC has also approved the resolution plan and it will be very difficult how to accommodate these people who are coming late. So that was also the discussion. The list of creditors has already been published. We thus do not find any ground to interfere with the order of the adjudicating authority rejecting their application for admission of their claim. However, their claim needs to be dealt in a manner which we shall deal in later part of this judgment. First question is answered. The adjudicating authority has rightly rejected it. The RP has rightly rejected it. However, how to deal with that we are going to tell you in this judgment. How to deal with. Question number 2. The question number 2 was whether the approval of the resolution plan, the claim stands extinguished. Now in this case, the resolution professional and the successful resolution applicant collectively said that the claim should stand extinguished. The answer to be found in the statutory provision in section 31, subsection 1. The Supreme Court also said in Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company, while dealing with above question, held that once resolution plan is approved by the adjudicating authority, the claims as provided in the resolution plan shall stand frozen, and all such claims which are not part of the resolution plan shall stand extinguished. Ghanshyam Mishra, and this is what was referred for answering question number 2. It is thus clear, NCLAT said it is thus clear that the extinguishment of the claim of the appellant shall happen only after approval of the plan by the adjudicating authority, not by approval of the plan by the committee of creditors. So extinguishment not on CoC approval, extinguishment only on approval of adjudicating authority of a resolution plan. Now, the argument of the respondent that since the CoC has approved the resolution plan, the claim of the appellants have been extinguished cannot be accepted, as there is no extinguishment of claim of the appellant on approval of the plan by the CoC. So therefore, the question number 2 is answered. Now the question number 3 and 4. Question number 3 and 4, how they are to be dealt with, whether the information memorandum will have this information, what are the responsibilities of the SRA. So now this the question 3 and 4 is collectively handled. Now the unclad says, we are of the view that the claim of those home buyers who would not file their claim, but whose claim were rejected in the record of the corporate data, were reflected, ought to have been included in the information memorandum. 1, it should have been included in the information memorandum. The resolution applicant ought to have been taken note of the said liabilities, because it was also defined, the liabilities were defined. Then the regulation regarding information memorandum was also mentioned in the judgment. It is mentioned in the information memorandum that all the liabilities should be provided in the information memorandum. So then the unclad said that these the home buyers, the allottees who have given advance, they are liabilities, and the liabilities must be there in the information memorandum, even not submitted their claim. And of course, later on, there is another amendment in the regulation where the RP has been given a duty to write communication to all those people who are appearing in the books of account as the creditors as liabilities. Non-consideration of such claims which are reflected from the record leads to inequitable and unfair resolution as it's seen in the present case. Now, based on the inequitable and unfair resolution, now the following directions are given by the unclad. The resolution professional shall provide all details of the home buyers along with their claims as reflected from the records of the corporate debtor who had not filed their claims, including the appellants to the resolution applicant within a period of 1 month. This was direction, specific direction in this case, that we are not rejecting the resolution plan. We are keeping the resolution plan pending, which has been approved by the CoC. However, it is the duty of the RP to provide this information to the resolution applicant, and the resolution applicant shall prepare an addendum on the basis of the information as submitted by the RP and place the same before the CoC for a further period of 1 month. The CoC shall consider the addendum in its meeting, and decision of the CoC on the information memorandum addendum be placed with adjudicating authority. The CoC shall take decision in its meeting within a period of 1 month from the date of submission of the addendum. The adjudicating authority, while considering the approval of the resolution plan, which is pending, shall consider the addendum and the minutes of the CoC. So therefore, what happened? All these people, they would get a separate treatment. The resolution applicant will say how the treatment is being done, how they would be handled. So this is what is the crux of this Puneet Kaur judgment. And there was another issue which was discussed in the IP conclave, and that was what happens in case some homebuyers say that I paid in cash. What happened? Then there were various different opinions actually were being raised. But one, the final that we've been concluding is that yes, booking of a flat by making a payment in cash is a valid booking in case he has all appropriate documents of making payment, getting allotment letter, getting builder wire agreement, and that too, where the timelines are also verifiable. Now, also that particular entries are appearing in the books of account that the cash was received. And in case the cash is not received in the books of account, that means that it is a fraudulent activity by the promoters. They have taken cash from the some of the allottees, and they have also recorded in the books of accounts that they are allottees. They have also submitted their name to RERA. They have also submitted their name to public authorities, and that cash was not recorded in the books of accounts. So that is also a Section 66 application. So immediately that can be handled. However, the person who claims and who is ready to say that, yes, I paid cash and he has evidences that his name is appearing as an allotee, then we have no reason to reject a claim who says that I paid substantial part or some part in cash. And so there are various judgments on this, whether the receipts were issued or not by the company. I say, even if the receipt is not issued, but the name of that allotee is appearing in the list of allottees, which is submitted to RERA, or the list of allottees, which is submitted to some other government authority, or there are evidences that this particular or that particular person is receiving communications from the company for various other matters as an allotee. So in case there is a complete file showing that he was an allotee, a genuine allotee, then the RP has to accept that even if the payment is made in cash. Now, we actually have done this part as far as these claims are concerned. Let me see, if there is some questions. So I believe, I think Mr. Shiv Nandan Sharma was also there in the IP conclave yesterday. Also, he is saying the one that he's saying, wonderful work, please keep it up. Thank you very much, Shiv Nandan Sharma ji. Also, the claims, if not fully admitted, the reasons for admission shall also be sent along with the claim admission mail to the claimant. I agree. He is also suggesting that even if it is not fully rejected, partly rejected, the communication to the claimant must be stating why this is partly admitted. Now, Mr. Hari Prasad Ravuru is asking, the limitation is applicable to application under Section 7 or under Section 9. Can a claim which is barred by limitation be admitted by the IRP? No, my question in this regard, my answer in this regard would be that the RP is not an adjudicating authority. Now, as far as this verification of the limitation is concerned, there are various Supreme Court judgments, there are various other clauses of the Limitation Act, which is a completely an adjudication matter. It is not something that you can verify some facts and you can take a decision. No, the various evidences are required, whether it was renewed, whether the name was there in the books of account, whether there was name in the book balance sheet. So all these things still become a kind of adjudicating, where the RP is not supposed to adjudicate. So therefore, the RP should actually consider this as a limitation issue only on primary parameters, not really going very deep into the explanations given by the claimants. M.R. Gokada, which actually appears as the name from the email ID. In my case, one of the operational creditor, CoC formed with the operational creditors only, sent on their letterhead by the director of the company to exit from the CoC and withdrawal of the claim, stating no assets with the company, and further stated they would like to pursue their claims under Negotiable Instrument Act separately. Now I have filed a memo with the adjudicating authority and revised the claims. Is it correct? In the CoC, there is a right which is given to the claimant that the claim can be withdrawn. The claim can be withdrawn within a specific period. Otherwise, the modification of the claim is possible if there are reasons, but the overall claim can be withdrawn by the creditors. That is not acceptable. That is not acceptable. Somebody is not filing claim is different, but somebody is withdrawing the claim, we've never allowed it. Because see, there is no regulation which says that the claims once filed can be withdrawn. the RP has the power to modify it in case the figures are incorrect or there is a additional addendum received. It can be verified, it can be corrected, but claims can be withdrawn. In liquidation, in fact, we have filed some applications that in some of the parties actually have gone to the adjudicating authority for withdrawal of their claims because otherwise they are likely to contribute for the liquidation cost. So there is exclusion from CIRP period granted by the adjudicating authority and accepted the delayed claim. Is it correct? The exclusion from CIRP period granted by adjudicating authority is not the reason that the RP can accept a belated claim. The exclusion, the only thing is that the public notice was given in time. After the public notice, the claims are supposed to be filed within 14 days. And from that 14 days, 90 days is required. But that is the, in case, let us see this, the 90 days is, because the exclusion, I don't know, because this is not there in the question, whether the exclusion is between this first 90 days and also because of some reasons which are even applicable to public at large, that's not there. However, the exclusion does not give a power to the RP to admit belated claims. Now, the other question is, like, I think there was a hand which was raised. I just want to see whether this, whether I couldn't see the raised hands. I'm not able to see the raised hand. Let me check. Yes, there is one attendee who has raised. Okay, I'm just providing the Mr. Shiv Nandan Sharma in case he can unmute himself and in case he can ask his question. Sharma ji, like, do you want to ask a question?
I am actually wanting to make some statements, sir.
Yes, please.
The KV developer, I wanted to take 2 minutes only because you have a very short time in this whole process. On the claim side, I just thought I will add one line that in our case, what I did, the people started approaching the court under 65. So I suo moto increased the date by 30 days and informed the tribunal that the date is increased, and we are informing on the website of the CD that claims 30 days belated will be accepted, and the bench agreed with us. And a lot of IAs were, really saved. On the matter of KV developers, I think there is a big issue. When the KV developer judgment came, I waited for about 60 to 90 days that whether an appeal goes into Supreme Court or no. Because according to me, this was an apparent and a fair case to be taken to the Honorable Apex Tribunal. It has a prospective or retrospective applicability. It is very clear that the applicability is retrospective because it says till the plan is approved by AA, the claims are not crystallized. So all those home buyers which are left out can keep on approaching AA. So in our case, we had this major issue because our resolution applicant had said that whichever claims have not come, they are all extinguished. So his financial viability was based on that. So like say, let's say 50 claims are still to be received, but he treated them as an unsold portion and took a revenue. So I had a major problem. So I suo moto approached the tribunal. I suo moto approached the SRA and convened a further CoC meeting after submission of plan. After almost 10 months of submission of plans before AA, that the plan was modified and addendum was given to address those claimants who had not been admitted. In my particular case, I had one major issue that I had no record available. So I had no list of home buyers. I only knew the number of flats, that there are 300 flats sold and 270 or 250 claims received.
I think
so
these are all facts of the case. I think
And I say that in
I
case
think the
any of
important
my
part,
friends,
the very, very important thing which Mr. Sharma is saying, that he suo moto filed an application for extension of the claim submission period, and that was
because
admitted.
this
That
is
was admitted by the
retrospective,
adjudicating authority. So I
because
think
this is
this is
retrospective.
one thing we can definitely advise our audience, that this can also be one of the way to reduce the litigation. So thank you, Sharma ji. This is
Thanks,
also
sir.
very
Thank you.
important, very, very important input that you have given. Thanks a lot. Thank you. Thank you very much. So now coming back to our own, just give me 1 minute. And now, so I think now we are okay. Let me take one more question, because see, there are many questions. Now the question which is on claim of EPFO for employee contribution as well as interest penalty levied by EPFO is okay, and it has to be admitted in full as per various NCLT orders. What about the damages being claimed by EPFO because the damages are not credited to the account of the employees of the CD, and the amount of damages goes to general fund of EPFO? When the amount of damages is not being credited to the account of workmen and employees, why the amount of damages to be admitted by the IRP RP? No, we actually analyze this very carefully, this issue, and our opinion is, although there is no judicial pronouncement on this, our opinion is that the intent of the lawmaker is that whatever employee contribution or employer contribution which goes to the account of employee, that must be protected. Now, any other non-compliances, like the delay in submission of the returns, delay in payment, and also the various damages that are being charged, these are something which actually are statutory authorities' claims on the company. Now, the statutory authorities' claim on the company is an operational creditor. So when we admit these claims, we should actually ask the bifurcation of their claim from the EPFO. In the bifurcation, we should clearly ask the employer's contribution and employee's contribution. These are the amount which should be separately admitted, and these, as per the various judgments, these are supposed to be paid in full, and also it is to be provided in the resolution plans as has been held in the Jet Airways judgment by Honorable Supreme Court, that we must provide for the full payment of the Provident Fund and gratuity in the resolution plans as well. However, the remaining part, which can be some kind of penalties, some kind of interest, and some kind of damages, those claims should be admitted as operational creditor in the name of the EPFO. This is what is our opinion. However, there is no judgment. Once we start doing this, then there will be some judgment, because then EPFO will go to the court. Now, we have a question from, like, the email ID says HKG. If there is a payment in cash as well as by checks, and the cash payment not accounted for in books of account of the CD, what quantum of payment should be considered for admission of claim? Now, first of all, we must see whether the builder buyer agreement, for example, says that it is the builder buyer agreement is for 40 lakhs. Out of that 40 lakhs, partly is received by check and partly is received by cash, and the same builder buyer agreement is continuing in the records of the corporate debtor as well. In case the cash payment is appearing in the books of account, we must admit. In case the cash payment, the receipt is available with the claimant, we must admit it. In case the allottee, in case definitely this is a person who is actually making partly in cash and partly in check, so that means this person is also appearing in the list of allottees before RERA in case it is submitted, or he's also getting regular communications from the company as an allottee. So therefore, the cash also can be admitted in case the cash is appearing in the books of accounts, and in case you feel that the evidences with the person is important, is very, very substantial evidences. And then we also should say that in case it is not appearing in the books of account, then we should say that the cash was definitely received because of these evidences. However, this was embezzled by the promoter, so section 66 also should be filed. Again, another question which is coming, in our case, the RP is rejected. RP is rejected the claims arising out of the arbitration and unrecovered portion of advances to CD. Now, during the process of argument, intimated that he will file affidavit admitting them as contingent as arbitration is under moratorium. It is correct stand. Is it a correct stand? As operational, we may lose the uncovered portion of MOB advances, etc. Not really understandable, this question. Now, as I say, when we see the definition of claims, it is very clearly said in the definition of claim that even if the claim is disputed, RP is bound to accept it. So even if a claim is disputed in an arbitration proceedings, RP must admit this, because the RP cannot adjudicate a matter which is already in arbitration. However, in the information memorandum, the RP will say that all this claim is admitted. However, these are subject to the arbitration outcome. And also the litigations must be mentioned in the information memorandum. So when the resolution plan will be submitted, in the resolution plan, the resolution applicant will submit that these claims which are subject to some arbitration or subject to some dispute will be handled accordingly and will only be paid once the amount payable to them is crystallized by the appropriate court. So this is what is my opinion. Now, one Riddhi Jain is asking which claim forms and in which capacity a claim form will be filed in a scenario if a person is a decree holder, as other creditors or the initial position before passing of the decree. Now, even if you get a decree, if you are an operational creditor, your decree also would be considered as an operational creditor. The status doesn't change from the operational creditor to financial creditor. Now, the decree holder will remain as the initial position of the debt. Whatever is the initial position of the debt, that will continue. In case of which is apparently barred by limitation, what type of prosecution can be, precautions can be taken by the RP to red flag such case? Should he mention that his concern in a primary communication to the claimant? Yes, I think he can say that in case some additional documents can be provided by the claimant, that actually will help him to admit, otherwise he may reject it, so that the additional documents should come from the claimant, and in case the case is tilted towards the claimant, it should be admitted, and in case it is tilted towards the corporate debtor, then it can be rejected also. Then that person will go and file an application, because the RP only has to now record reasons while he is trying to admit case, or while he is trying to reject a case or partly reject a case. Tanub, regarding EPFO claim, should you please clarify on how components like interest, damages, and penalty will be treated outside the waterfall as an operational debt? Now, the interest, damages, or penalty, these are the claims of a statutory authority, and the statutory authority's claims would be admitted as an operational creditor. It has been held. So those actually will be treated as operational creditors. Lalit Maheshwari is asking, when claim is rejected by RP but claim is within the Limitation Act, what recourse claimant has after resolution of the CD? Now, the claim is rejected by the RP and no application has been filed by the claimant before adjudicating authority. That means that the rejection has been accepted by the claimant. Now, once the rejection has been accepted by the claimant and thereafter the resolution plan has been approved by the adjudicating authority, then all claims will stand extinguished. Then no recourse would be available with the claimant because he should have filed an application when the claim was rejected. One anonymous attendee in case of Central Board of Trustee EPFO versus Shri Kumar Ranjan RP Hindustan newspaper Anklet Chennai held full dues including damages need to be paid. I'm not sure whether this was argued or not, because see, primarily the provident fund dues, whatever that section 36 subsection 4 subclause 4 is, when we see that clause, it only talks about the provident fund dues of the employees. It does not talk about the dues of EPFO. EPFO is a separate, because see, like EPFO has to say, because this may be a summary kind of a judgment, but I don't think somebody has argued on this carefully. And in case somebody has definitely argued, then it must go to Supreme Court that the claim of provident fund, employee contribution, employer contribution should be protected. But it is not really important that we should protect. In case we start protecting the penalties, damages, or interest charged by EPFO, then then the income tax department will say, GST department will say, the service tax department will say that they are also having such claims, and those are really, really important for them. So I have taken for the timing all questions. The other question Mr. Shivnandan Sharma is asking, I think only liquidation, the full amount of PF claim gets to be treated as senior most debt. No, it is not the senior most debt. No, in liquidation, when we see the judgments of like Sandesh Bhatt, these are the judgments which are saying that the section 36 of the liquidation of the code, section 36 says that the gratuity fund and the gratuity fund, provident fund, and superannuation fund, these are not to be taken over by the liquidator. So this is now finally coming up as kind of various judicial pronouncement. One, which is Jet Airways, is said that even in the resolution plan, the claim of the gratuity and the claim of the PF has to be paid in full. And in the case of liquidation, in the case of Mozarbeer, finally, the Supreme Court has said, and also in the case of ABG Shipyard, the Supreme Court has said. So the Supreme Court has said in these cases. However, in the case of Jet Airways, the Supreme Court has again said that it is to be paid. But the full, I'm not sure that the full, it is only like these are the opinions that we are creating, and somebody will file an appeal to Supreme Court that the EPFO is asking for the damages also. It is a detailed judgment referring to Jet Airways judgment. So as I said, the Jet Airways talks about the payment to the employees. Jet Airways is not talking about the payment to the EPFO. The Jet Airways is saying that anything which is due to the employees for provident fund, that has to be paid. So this is something which is not really dealt with by anyone. The segregation of the claim of the EPFO probably is not there. An allottee, then again, an anonymous attendee says that an allottee who has got relief of compensation under section 18 of RERA, and later on, when the builder company went into moratorium, the allottee did not submit a claim at the appropriate time to the IRP. Can he file a criminal complaint against the builder for not delivering possession or compensation? See, the claimant can file a criminal complaint against the builder because there is no moratorium on criminal cases, but the court will decide whether it's a criminal case or not. However, the promoter will say, now this company has gone into CIRP and moratorium has set in. I do not have access to my bank account. Even if I want to pay, I can't pay. So no cognizance will be taken by any criminal court when the promoter will say that I want to pay, but I can't pay because the company has gone into insolvency. logically, I have admitted the EPFO claim for employee. This is from Shiv Nandan Sharma. I have admitted the EPFO claim for employer contribution plus amount of interest that would have actually accrued to the employee as admitted. So we actually checked with one of the regional director. He was saying that we also give interest to employees in case it is delayed, deposited by the employer, and that is something which goes to the employee. So therefore, interest, if it goes to the employee account, that is something which is the dues of the employees. Now, another, again, the anonymous attendee is saying the claim filed as FC but had to be OC based on an arbitration award was not admitted by the RP and kept under verification since Section 34 petition filed by the corporate debtor was pending and remained pending during CIRP. The plan has been now approved. What should be the status of the claim filed by the creditor? No, the claim, in case it was not admitted by the RP, then it was not showing in the memorandum, then it is not even considered in the resolution plan. I believe the claimant has also not filed an application before the adjudicating authority. Now this stands to be extinguished. So all these claims stand to be extinguished. So the last question is, how do you handle interest on delay and damages penalty in case of ESI and PFI? So as far as this ESI is concerned, ESI is not protected. ESI is a service provider. ESI is providing a service to the employees where the contribution is coming from the employer. So ESI is not protected like gratuity or the provident fund. ESI is a statutory payment and it has to be admitted as a statutory claim, and it will be an operational creditor in CIRP as well as in the liquidation. So going forward, I think we have done this. I will go to the Adinath Jewelry Exports versus Mr. Brijinder Kumar Mishra, and that is in the case of Shri Nuj and Company Limited. This judgment is April 23. Judgment is from Justice Rakesh Kumar and Dr. Shlok Srivastava. So in this case, again, it was a case where the Adinath Jewelry Export entered into a leave and license agreement for taking the premises for house for a period of 3 years. Then the CIRP was initiated against the Shri Nuj and Company, the corporate debtor, by an order of adjudicating authority, and during the subsistence of the moratorium, the resolution professional extended the lease and license agreement. Thereafter, an order for the liquidation was passed. Now, in this case also, the RP extended the leave and license agreement for some period because the RP thought that the rent is coming and that should be meeting some of the CIRP cost also. And then the liquidation order was passed, and then the liquidator said that now we have sold this particular property, and then like even in that case, the tenant in fact went to a small cause court at Mumbai and took a stay order. It took a stay order. Now in this case, finally the court has held that the property has to be vacated. There is no locus of small causes court at Mumbai. Status quo during moratorium would not persist. So whether the NCLT was correct in passing the impugned order for putting the said premises under lock and key of the liquidator once a status quo order has been passed by the small causes court Mumbai. See, the NCLT said that the liquidator should put their lock and key. Liquidator should take the possession, control, and custody of that property which was given on lease, and the lease has expired. The status quo given by small causes court of Mumbai is not relevant, and then the reference was given to the powers of the liquidator under section 35 subsection 1 and clause D, and also section 33(5). Finally, the decision of the NCLAT. The decision of the NCLAT is that the residuary jurisdiction is relevant during CIRP when the insolvency resolution of the corporate debtor is taking place, whereas in the present case, the liquidation of the corporate debtor is being considered and the liquidator has taken recourse to its powers under section 33 subsection 5 to get control and custody. once the property was part of the liquidation estate. So first of all, it was made sure that the property is part of the liquidation estate. It is not a property which is given on lease to someone and the lease is not valid, the leave and license is not valid. So the lease and leave and license is all completely, it has actually been expired. Therefore, the section 236 of the IBC prohibited the applicability of any other law which was inconsistent with IBC. The status quo order passed by Small Causes Court of Mumbai without placing full and complete facts is not sustainable. And finally, the NCLT, the appeal was dismissed, and the order of the adjudicating authority, where the liquidator was empowered to take the control and custody of a property which is on lease and the lease is expired. One more judgment I will take, and this is in the case of Bhushan Shringarpure versus BK Mishra, the RP of Lakeland Chemicals India Private Limited. This is one case. I think this is all the insolvency professionals must be careful. Section 24, subsection 3 of clause, and the clause C says that when the claim of the operational creditors are more than 10% of the total debt of the company, it is the duty of the RP to invite operational creditors in the meeting of the CoC. It is not something which is supposed to be invited to everyone. The OCs, the operational creditors, are supposed to find out their representative who would be representing the operational creditors. The RP must provide a platform to them so that they can choose their representative in the CoC meeting, who would come and will not have any power to vote. However, they will only finally see and view the meetings, so that also they have no power to vote. But in one case is the RP didn't do this part. RP didn't do this part. So one of the person, he in fact challenged the entire process and said that the RP has not done this. So therefore, all this should be considered as not appropriate. And finally, it was held by the NCLAT, one, that it is mandatory for the RP to do this. Then the RP in this case has not done this, and that should have been done. However, the impact on the operational creditor is not much. Therefore, they don't feel like rejecting the resolution plan. However, the RP was found to be doing a dereliction of the duties of the RP, and he was fined an amount of rupees 1 lakh. Now, once the NCLAT puts a fine on the RP, then even the IBBI will also give a show cause notice. That's what is my feeling. So this is very important. Let us not forget, we have to choose a representative from the operational creditors in case their total claims are more than 10% of the total debt. So that's very, very important. So this is all for the day, although I have a couple of more judgments, but like I got a fee, I've got kind of so I got the request from some of my listeners and viewers that it should be more participative. So we will be making it more participative. Please do ask questions and we would be answering the question. And in case we find that somebody is really interested in contributing a new fact, that we will also add in our weekly webinars on Saturday. Thank you very much. And we really love you when you all come in such huge numbers. We really love you. Thank you. Thank you very much.